Your will, your wishes. This is just going to be a practical session on wills and estate planning, things that I think are important for us to know about this topic, especially as finance brokers. As I've said before many times, I think that we are in a position of absolute trust with our clients, and this conversation is really quite an easy one to have. With that being said, I do want to hit you with a quick disclaimer. Obviously, this is general advice. Obviously, the things I'm talking about here with wills and estate planning is more really in the legal sphere. And so anything I say today should obviously be checked with a legal professional at some point and is based on general information only. So if you have clients that you're referring to someone, make sure they do go and talk to those people about that. But here we go. Let's get into it. What is a will? Well, a will really isn't just about someone's death. It's about actually reducing uncertainty when that event eventually does happen. So we're all going to pass away at some point, and what happens when we do is the topic of this whole webinar. So practically today, what is a will? Well, we're going to talk about a few things. So the first thing is what a will does. The second thing is, and this is a really important item to cover, is what happens if you don't have a will. And I'm not sure exactly what the stats are, but I believe the last time I checked this, about 50% of Australians don't actually have a will, and that's really quite a concern. Number three is what you need to decide. So when you start working on your will, the things that you need to think about and decide on, and then the things that actually sit outside of a will, which there are some things that do indeed sit outside of your will document. So what is a will? Well, a will is, it's an instruction manual, really. It is about the directions that you leave behind in relation to the things that you are leaving behind. So we all know, I'm sure, that we can't take things with us when we pass away. I'm not sure that anyone has proven that we can. I know that back in the ancient Egyptian days and even back in the medieval times, we had kings and pharaohs buried with a lot of their stuff, but I dare say they probably didn't take it with them to the afterlife. But it's all about what you leave behind: property, cash, your stuff, so your belongings, any debts, interestingly enough, any debts that you have left behind, so mortgages or other forms of finance, and any interests or rights that you might have, say, in a business or investments, that sort of thing. So broadly, this is referred to as your estate. So what is the composition of your estate? The second thing that a will has in it is beneficiaries. So a will document will say what you want to have, or who you want things to go to. So these are broadly known as your beneficiaries, and they could be people, they could be charitable organizations. I know we've heard stories over the past years about people leaving things to pets, interestingly enough. So, and it doesn't always have to be a family member either. It could be a good friend, it could be a godchild, perhaps, something like that. And then the third thing that comprises the will is the executor. So what is an executor? Well, an executor is going to be the person who is charged with the responsibility of carrying out the wishes in your will. So that's the person who will effectively administer your estate. So what happens if you die without a will? Well, that's called dying intestate, which means without a will or without a testament. And that's a real issue if people die without a will. And there's three key reasons why that's a problem. So the first thing is that if you die without having written down what your wishes are, then no one knows what those are. Sometimes you hear stories, or you may have heard stories of people that have said, well, Mom and Dad wanted this to happen, or I had a conversation with someone and this is what they said. And unfortunately, you can't really rely on that because it isn't written down. And that's the way the court would look at that, is if it isn't written down, then it's very difficult to say that that's what that person wanted. The other thing is that someone will need to have authority over your estate. And in the absence of a will and an executor, that is usually falls upon the court to decide what happens to your estate. And that term is known as probate. It goes into a probate. Every will, by the way, goes into probate. It's just, every estate goes into probate. It's just whether or not it gets out of probate quickly because there's a will document that has explained what your wishes are. And then, of course, if you don't have a will, then many times family conflicts do ensue, and people start arguing about the belongings, the money, the wishes of that person. So it's really can be really quite a mess if you don't have a will. So hopefully, even though we're on slide 6, you've hopefully understood that by now, that a will is a really important document to get created. So let's just talk about a couple of myths that I often hear about from my clients sometimes, and from even people that I have this conversation about. And they all make sense. They're understandable. I can see why people might view it this way, but let's just dispel all of these. So the first thing is I'm too young. I hear this a lot. People go, well, I don't really have anything, or I'm too young, and I don't really, what do I need a will for? It's just me. That's often what I hear, particularly from younger single people. And so the reality is that you do have things. You might have superannuation. You might have stuff. So if you've moved out of home, then it's likely you have, even if it's only a little bit, you'll have some jewelry. You'll have cash in your bank account. You'll have maybe a car, your super, as I already mentioned. Heck, you might even have a pet, a dog or a cat or a fish or a bird or something like that. So the reality is that if you're over the age of 18, you're legally an adult, and you really should have, even if it's a very basic will, you should have that will. The other thing that is interesting about a will document that also ought to be mentioned for young people in particular is the will often stipulate what you want done with your body. So do you want to be buried? Do you want to have what sort of funeral do you want to have? Do you want to be cremated? Do you want to do one of those things now where you get put into a pod and a tree is planted over your body, that sort of thing. So even then, the will document can stipulate those sorts of things. The second myth is that, if I die, well, my partner or my spouse just will get everything. And, lawyers are often, when you ask a lawyer a question about something, they often are very fond of saying, well, it depends. And of course, that depends. My partner gets everything depends on ownership structures. So if you have stuff through companies or trusts or other legal structures, it may not necessarily pass to someone else. Or if there's no instructions about those things, then there could be confusion about that. So you wouldn't necessarily just want to assume that my partner gets everything. Probably the third most common thing that I hear is, well, I did my will, 20 years ago, and we got all of our instructions down, and it's okay. And that's good. At least you have a will. So even though a will might be 10, 15, 20 years plus old, at least you have one. So that's a start. However, laws change as a result of court cases and things like that. Sometimes language needs to be updated in will documentation. So even though a client might say, well, I've done my will and I've had it for 20 years, it would be worth knowing, or not knowing, but it would be worth having it reviewed to see if there's any language or anything that might need to be updated. And sometimes people find that there are things that they put in their will 20 years ago that they completely forgot about, that are no longer relevant today. So reviewing a will, I sort of suggest a will review should be done anytime there's a major change. For example, if there is a change in a marriage, so you have a marriage, a divorce, something like that, any big life changes can invalidate or make a will no longer the old will, no longer the document that you would want to use. It needs, in other words, it needs to be updated. Number 4 is a big one. So a lot of people go, well, I don't really have enough stuff. As I was saying earlier in point 1 around young people, that's often their particular statement is, I don't really have enough to worry about. And as I've already alluded to, even something as simple as what you want done with your body when you pass away is something that you would put in a will. But as you get older, certainly, and older Australians, and I love the comment there about sentimental items. You might have some things that you've collected. Like right behind me is a jersey from the Wartahs. It's autographed and everything else. Now, no one in my family has expressed any interest in having that, and I haven't ever. I mean, it's not in my will what to do with that jersey on the wall. But it could be something, for example, that would be something I should update my will on, because I only got that thing maybe 10 years ago, and our wills are probably, well, actually, I will admit, my will does need to be reviewed, and my wife and I are in the process of doing that. So then I don't own enough. That's not an excuse or a reason to not have a will. Finally, a common one is my family knows what I want done with stuff. And that's all well and good. And that's great if you do have family members that you have had a conversation with and you say, you know what, that old classic car that I bought many, many years ago that's sitting in the garage, Dad said that he wants to give that to me. And you may have had that conversation around the dinner table with family members, but the reality is that it's not in writing, and there's no authority to establish that that is actually the case. So again, it is critical that these things get written down and properly done so that there is no ambiguity around that thing when you do eventually pass away. So what does a will actually help do in terms of reducing some burdens? Well, first of all, and I love this line, it gives you the gift of clarity. A will clarifies, again, what you want done with a number of things. The first thing it does in relation to clarity is it gets rid of uncertainty. So people don't have to guess what it is that you wanted done. They don't have to guess what your wishes were. That's really important because, again, this is where a lot of disputes begin. Is one family member might say, well, mom or dad said they want this to happen. Another family member might say, well, I don't remember that. They actually told me something completely different. And so having a will remove those uncertainties because it becomes a document that the family can actually rely on and have a conversation about. Probably number two is the biggest for me, is that it reduces delay. I mentioned earlier that every estate goes through a probate process, regardless of whether you have a will. A will just makes it much faster because the instructions are there. Hopefully they're clear. Hopefully they cover everything in the estate as well. And so a judge can get a will or an estate, rather, out of probate much faster if you have clear instructions on those things. I've heard of wills taking sometimes years to actually get through, or estates, I should say, years to get through. And that is often because there is ambiguity or some other unclear thing about that estate that has caused it to be delayed. Three is a cost factor. Certainly, if there is a will document in place and it's clear and there are clear instructions, then it reduces the possibility of having disputes. And that's really important, especially, and I think there's a slide on this, or I'll cover this off in a moment, but especially where you have blended families, and that's happening more and more these days, is you certainly don't want people arguing the old, the children from a previous marriage arguing with the children from the current marriage or whatever about things. And that's probably number four. It's touching on number four as well, which is a good will document will help reduce any conflict because of those sorts of things. So again, just reinforcing that a clear set of instructions and wishes will go a long way. Let's get into some of the particulars and the nitty-gritty of a will. So the first thing is that a will, in a will document, you have to choose someone to be the executor. So what is the executor? Well, it's basically the person who is going to be responsible for executing on the instructions left in the will. And ideally, of course, you want that person to have some of these attributes. You certainly want to be able to trust them and have them be a fairly organized person. Probably that second bullet point is a key thing, is you want them to be available and willing to do it. So when you are speaking to clients about establishing a will, and you might say to them, have you thought about who you might want your executor to be? Because the lawyer is going to ask you that. And they might say, yeah, sure, I'm going to name my brother, my sister, or so-and-so. One thing you can do, and it's obviously not legal advice, or I don't think it's legal advice, is you can say, well, have you actually spoken to that person about it? Have you asked them if they would be willing to be an executor? Because I will say that job is a pretty big job, and it's a really important job as well. And sometimes people agree to do it, and then they don't realize how involved it is or can be. So that's really important. That person will need to be able to deal with institutions and all the paperwork. That's why you'd probably want it to be a reasonably mature adult. They need to be able to have a good relationship with the people involved, be calm about things, etc. And finally, if that person is at the time of your passing and the will being dealt with, they might not be able to do it. So, for example, if you had named someone maybe 20 years ago, it's possible that that person has passed away or is too old now to want to do it. And so having a backup executor is also really important. And you can even name several people as backup executors and just have a flow of that sort of thing. So what is a will? Well, it's a set of decisions, as we've been discussing. And these are the probably key areas that need to be considered and thought about, really even before you start drafting or even maybe visit with a solicitor. And the first thing is, who are the people that are going to be involved? So who do I want as the beneficiaries of my estate? Who's going to be the executor, as we've just been discussing, and a backup executor? If you have young children, or you're dealing with a client with young children, a conversation that I always recommend my clients have is, who do you want to be the guardian for your children? That's a really important one that I think often gets overlooked, because people think, well, grandma and grandpa are around, they might, they take over and raise the kids or whatever. They may not be interested in doing that because, they already raised you and they're, I'm sure, involved in their grandchildren's lives, but may not want to take on the responsibility of actually raising those kids, those children. And so that's a critical question to ask. The second area is over all of the various assets, so the property. So that includes things like any money, any cash, any investments that you have, the family home, any investment properties, all your valuables, any sentimental items. I don't know. I don't hear it too often, but I have things that when my mother passes away that I would like to bring back to Australia, things, little trinkets and things that she's had around the house that have been part of my life growing up that I wouldn't mind having. And I haven't necessarily talked to my brother about all of those things. Luckily, there's only the two of us that will have to argue about that stuff. But nevertheless, I suppose if there was something that I really wanted, and I should be saying to my mother, can you just put that in your will? And I would have that conversation with my brother and say, well, I'd like to have that thing, and we'll get it in Mom's will. So those are those things that some people, again, sometimes overlook. Finally, pets, your personal wishes, the funeral preferences, those are the things that I was mentioning earlier, is there may be things or pets, animals that are left over after you pass, that are, I shouldn't say left over, but you know what I mean, that were left behind, it's probably the better way to put it, after you pass, that need to have instructions left on those things. And so that is, again, the things you have to start thinking about before you even see a solicitor is, what are your preferences? What do you want to happen with those things? Now, a will, while it is central to all of this estate planning stuff, it isn't the only thing. It's not the whole plan. And interestingly, there are documents that form part of that estate and will that govern what happens if you're still alive. Before I get to that, just a couple of the other bullet points on this slide. Superannuation, as I'm sure you would all know, because hopefully you yourself have organized your death benefit nomination. Superannuation doesn't really form part of your estate. It is a non-estate asset because it has its own separate death benefit nominations. And you can decide what happens with your superannuation directly through those death benefit nomination forms, and those forms would take precedent over your will. That is unless, of course, you say legal personal representative on the death benefit nomination of your super, in which case it would be, in most cases, it would be the executor of the will who would take instructions on that from your will to deal with your superannuation. But many people just have death benefit nominations on their super, and therefore those death benefits get paid directly to whomever those beneficiaries are. Jointly owned property is also an interesting one because there's not an absolute lay down misere guarantee that if it's a jointly owned property, that just because one person passes away, that property automatically passes. There are some things, if tenants in common are on a title, that means that, and even if you're married, that would mean that your spouse, the tenants in common piece would be dealt with in the will. So again, this is something that you would want to highlight to the client if that's how they set up their property ownership structures, and discuss that with an estate planning professional. Investment properties, if owned in one spouse's name, doesn't automatically pass to that other spouse. So how many of us do investment lending where a loan and a property is put in one of the spouse's names because they want to have some more tax efficiency or whatever? Well, again, this is where a will document comes into play, because that property doesn't automatically pass to the surviving spouse because it's not their name isn't anywhere on it. So again, important things to consider. We've already kind of touched on we've touched on superannuation, but life insurance is another big thing, and that will flow sometimes out of superannuation, because there is, in many industry funds, there's a life insurance component that also has beneficiary nomination forms and things separately that'll have to be completed. But if the life insurance policy isn't owned through like an industry fund, and you have an individual policy, again, a great conversation piece to have with clients is, how have you set up your life insurance policies? Who are the beneficiaries of those policies, and what nominations do you have there? We've already touched on trusts and companies and other business interests. Again, a will document will help with the transfer of control in things like a company or a trust. And certainly if you have clients who are business people who have business partners, or even just businesses, like, for example, I'm the sole proprietor really of my business. And so I'm pretty sure, I haven't looked at my will in a while, I must admit, but I'm pretty sure my will deals with that in some way, shape, or form. And again, just a great conversation item for you to have with your clients. Finally, and this is, again, often an overlooked thing, is the powers of attorney. If you are alive and incapacitated, and there isn't a document that says that this person has my power of attorney, then sometimes there is a lot of ambiguity around that, and that can cause concern. So an example of that would be if you are incapacitated. So let's say you get into a car accident and you're in a coma. If you don't have a power of attorney that you've given to someone, and usually it's spouse to spouse, then decisions may not be able to be made on your behalf. And that's what a power of attorney is all about, is in this example, if you were incapacitated and you had given a power of attorney to your wife to make financial decisions and stuff, and that power of attorney was registered, and all of the things that powers of attorney need to have happen so that they're effective and registered, they can then, for example, go to the bank and do things on your behalf, and the bank has to honor that document. So again, it's not just about the will, it's also about other ancillary documentation that floats around this. So hopefully you're seeing now that an estate plan and wills and all of these things are actually quite involved, and not just as simple as saying, I've got a will kit from the post office and I've filled it out. There's a little bit more to it. Probably one of the key things that I'm finding at the moment when I have conversations with clients is, the first thing I'll say is, well, do you have a will? And of course, many of them say, yes, I've done my will. We did it years ago or whatever. And I say, well, where is it? Do you know where it is? And more often than not, I get a bit of a quizzical look on a face that's just sort of like, I'm not really sure where my will is. And so what I say to them is, well, go find it, please. Usually you start with the solicitor that did it, or the firm that did it. That's the most likely place that it will be. But if not, dig around the house and find out if you've left it somewhere, or have it in maybe a safe storage box or something like that, fireproof document holder, in the house somewhere. And I also say you should probably give your will to a few people. I offer my clients that I will hold their will in their file if they so desire. just so there's another copy floating around. But having that original document is really important. I don't take originals, by the way. That's usually held by the solicitor, and copies are floating around. The next thing, of course, and these are all documents that you should probably have in what you might call your document box, such that when you do pass away, the executor is able to quickly find information and begin executing on the process. But Superfund information, any insurance policies you might have, obviously things like your banking arrangements, any loans, any other property titles, or just mortgage documents, things like that. Believe it or not, things like your birth and marriage and other marriage certificates and other documentation like that sometimes are important. And of course, when someone passes away, you get a death certificate as well. I don't know how quickly those get issued in Australia, hopefully within a month or so of a person's death. And that's a document as well that you'll need as an executor to actually carry out the wishes of the deceased. This is another biggie, especially in this day and age now, with everything being on digital platforms, is having some sort of digital management clause or phrase or whatever in the will documentation, where you can get control of that person's digital life as well, because that's something that you would probably want to eventually shut down as well. So how do we talk about this with our clients without making it overly depressing or burdensome? And I think it's quite simple. It's just we want to have that conversation from a place of being genuine with our clients, with concern, and ensuring that they know that we care about ultimately their financial lives, and of course what will happen after they pass away. And so you can just you could just have a very basic one-liner there. You could just say, doing some estate planning, not because there's anything wrong, but because you want to make things easier if something happens. Now, we all know that it's a question of when, not if, that we're going to pass away, but certainly that's an easy way to initiate that conversation. And I think that you can ask them, do you have an executor? Do you know where your will is? Do you know, or do you have key advisors that are working with you on all of this? And do you have some documents in a safe place so that people can find them? And these are all very basic questions. And interestingly, when you challenge people with a lot of those questions, they may not know the answer to that. And it will highlight to them, again, the importance of having this part of their life locked down. And one thing I can say is, because I say this to clients all the time, is that a will is something you don't do very often. And this sort of thing is not something you're doing every year. You're probably reviewing this when certain things happen in life, and it isn't, again, every year, maybe not even every 5 years. It could be much more infrequent than that. So here's a couple of ideas on things that happen during our lives that might trigger a review of a will. And again, as finance brokers and in the financial services industry, one of those key things is number two. But let's start with number one, because we see this all the time as well. As someone says, well, I'm getting married, or I've been separated, or I'm getting divorced, and even things like children and stuff, but that's probably the biggie, is marriage and divorce are going to be the biggies, where not just will documentation needs to be updated, but things like death nomination forms in Super. The number of times over the years that I've had clients who have been divorced and even remarried, and I will ask them, or during the process of doing a financial plan, I will say, who are your beneficiaries on your Super? And they'll go, oh yeah, I meant to update that. My ex-wife is my beneficiary. And I think, okay, maybe you wanted that, but then I will typically follow up and say, well, do you want your ex-wife to get all of your Super? And they're like, oh, no, definitely not. I want it to go to my kids. So again, this is an area where sometimes people just forget about this stuff. They don't think about it at the time, of course, because whatever they're going through with a marriage, or, well, in this case, a divorce, could be very traumatic for them, and they're not thinking about this stuff. And again, this is where we can really add value as trusted advisors. The second biggie is usually around a financial transaction. So they purchase a home, or an investment property. They might have an inheritance. They purchase or even sell a business. That's often a time when you have something that it needs to be updated in a will. Any big debts that get taken on or even repaid, that's when a will probably needs to be updated. So big money changes in life. The third one is those family changes that I was talking about. So the most obvious one is a divorce or even a marriage, if it's a blended family, where you would want to update your will to cater for the needs of the children and so forth. And if you are lucky to have grandchildren coming in onto the scene, and this is very topical now because we're going through one of the greatest wealth transfers in the history of humankind, the grandparents may want to now update and give some money directly to the grandkids. This is happening all the time. It's because the kids are usually pretty well sorted, especially if they're over the age of, I would say, 45. They would have done very well in life. And the grandparents, as I was saying, may very well want to pass some money on to them. And then finally, the fourth thing is any changes in key people that might be named in the actual will document. So thinking about the executors I was talking about earlier, if you did your will a long time ago, you may have an executor named that could possibly have passed on or may not be willing to or able to be the executor of the will. So again, that's where you would want to potentially make some changes. And it could just be that person may no longer be suitable. You might have had a falling out with someone who you had asked to do your executor. Now, I do have a little bit of a discussion item, which I don't think we'll actually go through, but I will just quickly highlight this particular scenario. And that is, we have a person named Sam. He's 42. He's separated but not divorced. He has 2 kids. He has a new partner, so it looks like he's on his way to getting divorced. He's got super, he's got a car, and he has a small business, and he has a home loan. And he dies, and he doesn't have a will, and that's a really tough situation to be in. I think you can probably see immediately, if you've been in this webinar since the beginning of it, that Sam's soon-to-be ex-wife, not quite yet ex-wife, has a problem. Potentially the new partner may have a problem. And we don't know how old the kids are, if they're under the age of 18 or over the age of 18. But there's certainly issues. And at the moment, Sam doesn't have anybody who is going to sort things out because there's no will, there's no executor, there's no instructions. We don't know whether he's got insurance in his super or any other additional insurance. And it's really what I would classify as an absolute disaster for this family. Could take a long time, and you could see to sort out the estate, and you could see where there are going to be disagreements right out of the gate because there's a new partner involved, and it's going to get very, very messy. So with all of that being said, what are some things that you could practically do in the next week? If you don't have a will, I would take action. Contact a solicitor. If you have someone that you've dealt with before for other matters who might do general law stuff, seek them out. If you have someone who has done a will for you before, fantastic. Maybe it's time to get it reviewed. That's the first thing. And if you don't have a will, then most definitely get out there and do something about that. The next thing is to check your superannuation. So as I mentioned, super does not form part of your estate unless you want it to, and checking your death benefit nominations for super would be a great first step, because oftentimes outside of our family home, our superannuation is our next biggest asset that's going to get transferred to someone. And you certainly want that asset going to, in the first instance, to a financial dependent, which would be a spouse or children, dependent children. But having death benefit nominations that are valid inside of the super is really important. The next thing is, of course, and this is probably more a comment for the finance brokers in the room, where you've just, say, written a big mortgage for a client or refinanced that client, you could absolutely have that conversation with them and say, hey, have you updated your will? And you might be surprised at how many people, again, give you that bit of sort of tilted, head tilt look, kind of like, what do you mean? Why would I do that? Great opportunity to have a conversation about that. The fourth thing is, again, if you don't have a will, or even if you haven't reviewed your will in a while, would be to maybe just make a list of all the assets and the things that you've got. And you might be surprised actually at how much stuff and responsibility and financial assets you actually have, and that it might be, again, time to ensure that all of those things are being catered for in your will documentation. And then finally, I think this is really important, is talk to your family about this stuff. Have a conversation. If you have a more mature family, so I do, all my kids are over the age of 18, and we don't do this as often probably as we should. So here you go. I've got an action item out of this webinar as well, which is to really start talking to our family about all of these things and letting them know what's going on. One thing I do know that we need to do is review our executor for our will, for my family's will, and make sure that someone is agreed to take that on. The final thing I'll just say about all of this is that when people pass away, the family's going to want to grieve, and they're going to be distracted by that. And that is important, that process happen, of course. And then the next thing that's going to start happening is that family's going to want to know where all the assets are, where the money is, and then what were the wishes of the deceased. And so I think if you view a will as an act of care from you to your beneficiaries and your family, then it becomes far easier, I think, to tackle this subject and to do the things that we've covered off today that need to be done for wills and estate planning. With that, I'm going to say, disclaimer at the end as well. I'm going to say thank you for joining me today on this webinar. Have a great rest of the day and a great week. Cheers, everyone.